Hey, gun people. This is a pretty good little case. I'm not sure where it came up. I was reading somewhere, and this case came up, so I figured we'd talk about it. They don't have the oral agreement like they do in the Heller case. You notice they have oral arguments in the opinion. They don't have that in this case. So I'm going to go over it on what they wrote about it and just kind of go over some points that I think are interesting about liberal judges versus conservative judges. So this is a 2016 case. So here's some facts about the case. Jamie was convicted possession of a stun gun in Massachusetts. She appealed and claimed her conviction violated her Second Amendment right to possess a stun gun in public for the purpose of self-defense, which was necessary to protect herself from her abusive ex-boyfriend. Now, you would think all women would automatically say absolutely and agree with her. Well, not if you're a liberal woman, because liberal women want to restrict gun ownership from women and everyone else because they want you to be a victim and they want you to depend on the government. But I digress. Let's stay on this point here. Self-defense. The Supreme Court of Massachusetts affirmed the conviction and said a stun gun is not eligible for Second Amendment protection. And the Supreme Court said, you're wrong. So the question was, does the Supreme Court protect the right to possess a stun gun for self-defense? And in a per curiam opinion, meaning 100%, everybody agrees. Now, in the Keller decision, everybody didn't agree. But in this decision, they all agreed. And the court held that stun guns are unusual in nature and were not common during the Second Amendment. They are included in Second Amendment protections. Would be inconsistent with the Supreme Court's decision of Columbia versus Heller, which held that the Second Amendment protections extends to arms that were not in existence at the time of the founding. Because the left wing that's been wanting gun control is trying to say that the Second Amendment only applied to flint and black powder guns. And it didn't include revolvers and semi-automatics and any other new guns because they weren't around on the Second Amendment. So that was their crazy left-wing argument that they tried to pass, and the Supreme Court said no. Luckily we had a majority of conservatives on the bench. Alito filed concurring opinion, and who did the primary? Oh, Clarence joined in the concurring opinion. So let's take a look at the opinion here. And again, there's no order, so we'll just kind of read through it here and discuss it. So this is the Massachusetts case they're talking about. And let's get this down here where we can read it. So, the court held the Second Amendment extends to all instruments that constitute bearable arms, even those that were not in existence at the founding. District of Columbia versus Heller. Now, on the Heller case, since that's pretty much what they use, I wanted to show you the Heller case. So in the Heller case, made it illegal to carry an unregistered firearm. Is this the Heller case? Or am I back to which case am I on? Yeah, Heller. District of Columbia versus Heller. So, made it illegal to carry an unregistered firearm, prohibited registration of firearms, so the chief of police could issue one a year license for handguns. The code also contained provisions that required gun owners to lawfully register firearms to keep them unloaded and disassembled and have a stinking trigger lock. Now that sounds like pretty much California's stupid crap. A gun, and I get this question all the time. Don't you keep your guns locked up? Hell no, I don't keep my guns locked up. What the hell good is a gun going to do when somebody does a home invasion and kicks my door in? Or somebody invades my property and wants to come and try to steal my car? Or, there's just or some crazy woman who picked a crazy guy, comes down the street and decides to run and bang on my door and go, help me, my husband's trying to kill me. And he kicks in my door because he thinks I'm going out with her. And now I got to go unlock my gun, find the bullets, load it in the dark, in a panic, and then I'm dead with an unloaded gun. And liberals go, yay, we prevented gun violence because they're freaking idiots. But I digress. All right, Heller. unloaded with a trigger lock unless the firearm is located at a place of business or being used for legal recreation activities. Basically, business owners could still carry their gun loaded and ready to protect their business, but homeowners could not. Legal recreation activities means shooting range. Heller was a D.C. special police officer who was authorized to carry a handgun while on duty. He applied for a 1-year license of a handgun. He wished to keep it at his home, but the application was denied. Of course it was, because government don't like guns. Heller sued and sought an injunction against the law enforcement that prevents him, violating his Second Amendment right, keeping a functional firearm without a license in his home. The district of court dismissed his complaint. The appeals court reversed and held that the Second Amendment protection for the right to keep and bear arms in the home for the purpose of self-defense, and the District of Columbia's requirement that the firearms be kept in the home non-functional violated that right. The question: does the provision of the District of Columbia Code restrict licensing of handguns, require firearms to be kept non-functional, violate the Second Amendment? What the hell good is the Second Amendment if you have to keep the gun non-functional? I mean, are you kidding me? It's just crazy. And how much clearer can the founders be when they put shall not be infringed? Well, obviously, these 4 judges here, liberal, left, loons, all said, no, Second Amendment should not count. Guns should be required unloaded, and they want to attach to only militias. And the conservative judges and the closet liberal went ahead and voted in favor. The ban on registered handguns and the requirement to keep handguns disassembled, non-functional with a trigger lock violate the Second Amendment. Scalia, great justice, good for you. That would be Mr. Scalia right there, who was killed by the left. I mean, who died mysteriously, and Obama didn't want to do an autopsy. But I digress. Let's see. In the Second Amendment, John Scalia discovered the opinion 5-4 majority. See, it's only by 1 stinking vote that our Constitution gets held onto. The whole purpose of the Supreme Court is to protect and defend the Constitution, to make sure laws are constitutional. And yet, we're still fighting 5-4 decisions because we get left-wing loons that hate freedom and hate the Constitution and hate anything that restricts government. But I digress. I'm sorry. Let me try to jump point. Let's see. Additionally, the term militia should not be confined to those serving in the military, because at the time the term referred to all able-bodied men who were capable of being called upon for such service. Don't we still have selective enforcement? Don't you still have to register at the post office when you turn 18? Maybe they stopped that. I don't know. To read the amendment as limited the right to bear arms only those in a governed military force would be to create exactly the type of state-sponsored force against the Second Amendment that was meant to protect people. Because the text of the amendment should read in a manner that gives the greatest effect to the plain meaning of it, shall not be infringed, would have had at the time it was written. The operative clause should be read to guarantee an individual's right to possess and carry firearms in case of confrontation, meaning self-protection, whether that confrontation is from a tyrannical government or a criminal or a teen or whoever. This reading is also in the line of legal writings at the time, subsequent scholar, therefore banning handguns, an entire class of arms that was commonly used for the protection purposes, and prohibiting firearms from being kept functional in the home, the area traditionally that you need protection, violated the Second Amendment. Good for the court. In dissent. That would be the left-wing loons. He said, unlimited right to possess guns and self-defense purposes. Instead, the natural reading of the amendment is that it protects the right to keep and bear arms for certain military purpose. It doesn't say that at all. That's how he's interpreting it. But does not curtail the legislative power to regulate non-military, meaning you pesky tax-paying civilians, of ownership of weapons. Justice Stevens argued that the amendment states it perfectly specifically in the relation to the state militias and does not address the right to use firearms in self-defense. So Stevens went as far as to say, you pesky tax-paying citizens who are supposed to be in charge of the government, who are supposed to be we the people, don't even have the right of self-defense. Is that liberal left-wing lunacy? That's exactly the way it is in the UK, Britain, and a lot of those places where they have taken guns. You do not have the right to defend yourself. You must rely on government. You must help the criminals load your stuff when they're committing a robbery in the car, or you get charged with interfering of a robbery or whatever they charge you with. So now that you understand the Heller case, let's get back to the other. So in this case, they reference the Heller case, and if you don't understand a Heller case or where it came from, you just keep hearing the name. Possession of guns, whether a stun gun or any other type of weapon, being protected by the Second Amendment. The court offered 3 explanations in this case, and this is the Massachusetts case. Stun guns are not protected because they were not common. That's BS. Heller already cleared that up. This is inconsistent with the Heller's clear statement that the Second Amendment extends to arms that were not in existence at the time of the founding. Great ruling. Good job. The court next asks whether stun guns are dangerous per se at common law and usual, according to Massachusetts. Okay, important limitations on the right to keep and carry firearms. The Heller case referred to the historical tradition of prohibiting the carrying of dangerous and unusual weapons. In doing so, the court concluded that stun guns are unusual because they are a thoroughly modern invention. Being equated to unusual within the common term of the Second Amendment Act, the court's second explanation is the same as the first. It is inconsistent with the Heller decision. Finally, the court said, in a contemporary lens, and found nothing in the record to suggest that stun guns are readily adaptable to use in the military. So again, they were trying to say because the military don't use stun guns, you don't have it because Second Amendment only applies to military. Okay, but Heller rejected that proposition that only those weapons useful in warfare are protected. It is not. It is also deemed for self-protection. For these 3 reasons, the explanation that the Massachusetts court offered for upholding the previous decision, consequently, they overturned. Let's see. The judgment of the Supreme Court vacated the Massachusetts ruling. So this is a good case for, and again, without the Heller case, you couldn't have had this decision. They wouldn't have had the precedents to go back to. So Supreme Court matters. It's always important to get a conservative, reasonable, not left-wing loons on the Supreme Court because their decisions have long-lasting impact, generations, and they can pretty much tear apart the Constitution one ruling at a time. All right, I thought it was an interesting case. Hopefully you got something out of it. We'll end that there.